Look at these 3 words written larger than the rest, with a special pride never written before or since. Tall words proudly saying, "We the people."
Good afternoon, folks. I'm Alexander Haberbusch, president of the Lex Rex Institute, and I'm a practicing constitutional attorney. Today, I'll be answering, as I usually do on Fridays, your questions about matters related to American law, or really, more particularly, about constitutional law. Now, as always, when watching any of our videos, please keep in mind that nothing in them constitutes legal advice. Seriously, don't use stuff that you hear on YouTube in a court of the law, whether it's our video or anybody else's. It's not a wise decision. Anyway, let's jump into this week's question. All right, this week's question is a short one. What is the Commerce Clause? Short one, but kind of a big one. We'll try to go over this briefly, just kind of give you an introduction to what the Commerce Clause is. So if you follow politics much, legislation from Congress, even from states really, you've probably heard the phrase Commerce Clause, and you may have heard it in a context that didn't seem to have a whole lot to do with commerce. Well, I'm going to explain why that is. We're going to get into what the Commerce Clause is, why it exists, and sort of what's been done with it in the time since then. But it's a little bit of a spoiler for looking ahead. Important thing to know about the Commerce Clause, really the reason that it's worth discussing at all, is it's a very good example of what can happen when constitutional interpretation goes awry. I think this clause has been expanded way, way beyond what it originally meant, but we'll get into that in a few minutes. First, let's start by looking at the actual text of the Commerce Clause. So let's go ahead and pull that up. Now, if you've watched our past videos or read any of our written material, you'll already know that one of the foundational concepts about the American Constitution is the idea of enumerated powers. That is, Congress can't do something unless the Constitution says Congress can do it. It's only got the powers the Constitution explicitly says that Congress has. Anything else is reserved to the states or to the people. So, if Congress has a power, the Constitution must mention it. So, if Congress can regulate commerce, the Constitution's got to say that somewhere. Now, if you remember in the past, we've looked at Article 1, Section 8 before. That is the section of the Constitution that lists the powers of Congress. It's not very long, about a page, I think. Yeah, maybe a little bit less, maybe a little bit more than that, but yeah, about a page looks like, page and a quarter. And so we've got to, if Congress can regulate commerce, it's got to be in here somewhere. So sure enough, a little bit down from the start, we find it right here. Congress has the power to regulate commerce, with foreign nations and among the several states and with the Indian tribes. Now, when we refer to the Commerce Clause, usually we're referring to the Interstate Commerce Clause, so we're referring to this part right here. And among the several states. 5 words, little words, it's not much. Turns out this is very, very important, and not necessarily because the Founding Fathers thought that it was important or intended it to be important, but sort of because of how this evolved in the years to come. So what was this intended to do? Well, clearly it's intended to avoid conflicts between states and other states. It's intended to avoid conflict between states and the federal government. You don't want to have one state saying, we're going to put a tariff on this other state. You don't want California saying you can't import things from Nevada unless you're subject to a tariff, because then you're basically like foreign nations at that point. You want to make sure that you have free, unrestrained trade between states. That's part of what makes you a nation. It's part of what's being remedied from what didn't really work too well under the Articles of Confederation. And, if Congress wants to say something like, well, goods used in interstate commerce, or say gold used in interstate commerce, will be measured in troy ounces. This would apply to that sort of thing. So, what sorts of conflicts could possibly come up with the Commerce Clause? Well, it turns out a whole lot, although people didn't really realize that for quite a while. We actually don't see any jurisprudence on the Commerce Clause for the first 35 years after the Constitution is ratified. And the first case that we end up seeing on the Commerce Clause is one called Gibbons v. Ogden. It's an 1824 case. And what this case had to do with was a 1798 law that the state of New York had passed, giving Robert Livingston exclusive right to navigation within the territorial waters of New York in boats that moved by steam or fire. All right, 1798. How many steamboats do you think there are in New York in 1798? Well, I don't know the exact number, but probably not many. Industrialization had just gotten started, but obviously over the next few years, you'd start getting a whole lot more steamboats. So people obviously started complaining. They didn't like that Robert Livingston was the only person who could navigate steamboats in the territorial waters of New York, and they sued over it under the Commerce Clause. Supreme Court ends up hearing this case, and John Marshall writes the opinion. Now, a few facts to keep in mind. Livingston had testified at the trial court level, I believe, that his boats were not even going to New Jersey. So I guess people who don't know geography, you should be aware that there actually is a river that divides New Jersey from New York. It's water. Territorial water of New York may also be territorial water of New Jersey. I don't know the exact jurisdiction there, but obviously people may be going from New York City across to New Jersey. It's entirely possible. Robert Livingston had testified that his steamboat company was not doing this. It was only navigating within New York proper. However, John Marshall looked at this case. Chief Justice John Marshall, obviously very famous Chief Justice, wrote two of the very most influential and important Supreme Court opinions, Marbury v. Madison, as well as McCulloch v. Maryland, and then Gibbons v. Ogden is a third one that's very, very important. And he looks at this case and he does a few things. Well, first of all, he says the issue in this case is Mr. Livingston's steamboats are not transporting goods, the sort of thing that you would ordinarily recognize to be commercial activity. His steamboats are only transporting people. Is that commerce? That's the first question. And the second question is that one that I alluded to a moment ago, which is that Mr. Livingston's steamboats may not actually be going to New Jersey, although this grant of monopoly would certainly give Mr. Livingston the right to navigate his boats to New Jersey. It's within the text of this law that had been written by the New York legislature. So that's the other question. Is that allowable? Does that constitute interstate whatever, whether it's commerce or not? Well, Supreme Court ends up saying, John Marshall in his opinion, the first thing he does in his opinion is he actually rejects the idea of strict construction of the Constitution's terms, specifically the term commerce. We're not going to construe that strictly. We are going to say that commerce can also pertain to navigation, and he does say that. Commerce includes navigation. Obviously not an obvious conclusion, maybe the right conclusion. I'm not going to voice too much of an opinion on that. And then he also says that even though the boats were not actually going to New Jersey, it didn't really matter because he had the right to do it. And there's some language in that case even saying that things that extend well into the interior of a state may still be part of interstate commerce. So he goes on to say that. And significantly, probably the most important part of this opinion is the section in which John Marshall talks about the Supremacy Clause, talks about when federal law overrules state law. And what he says is that because the Constitution, by its terms, gives to Congress the exclusive authority to regulate commerce between the states, that necessarily has the negative implication that states cannot regulate commerce between and among the several states. Well, we end up calling this as the Dormant Commerce Clause, or the negative implications of the Commerce Clause. What that does is that rules unconstitutional state laws that impose burdens on interstate commerce. And we'll get to that more at the end of this video. But this is the first in a very long train of cases that radically expand what the Commerce Clause is held to apply to. So, as I mentioned, 35 years after ratification of the Constitution, nothing had come up like this before, but obviously this turns out to be really important. In fact, some of the principles in this end up being the very same sorts of principles that lead to, well, a pretty significant event that you might have heard of before that happened in the 1860s and had to do with state sovereignty versus federal sovereignty. Other issues as well. I'm not saying those weren't part of the Civil War, but certainly it had to do with these principles that were raised in Gibbons v. Ogden, two radically different views of state power. All right, let's jump forward quite a bit. Well, actually, one more thing to keep in mind about Gibbons v. Ogden. Livingston, the guy that had this exclusive monopoly, was actually an ardent Jeffersonian, and Marshall, of course, was a strong Federalist, not big fan of Jeffersonians, and the opinion actually has some veiled criticisms of Jefferson's embargo that was in effect at the time. Marshall's often criticized for being a little bit more of a politician than a judge. I will let you make your own conclusions about that. Go ahead and read the opinion. It's worth noting. Comment in the description on this video or comments below in this video if that's something that you think is true. I'm not going to say too much about it, but must have felt good putting one of those Jeffersonians in his place. Anyway, next case we're going to look at jumps forward quite a bit to Swift and Company v. U.S. It's a 1905 case. What this case stands for, I'm not going to give all the facts behind it, but what it says is that Congress may regulate an activity, a local activity, that exists solely in one state, as long as that activity is part of the current or stream of interstate commerce. So, goods produced. So say you mine steel in one state, and then you transport that steel to build skyscrapers in a different state. Well, that's interstate commerce. The mining of that steel would also be interstate commerce because it's producing goods that are used in interstate commerce. And again, this gets expanded more and more throughout the years. You can already see it's a big step from Gibbons v. Ogden that we're at right now. This expansion of the Commerce Clause kicks into high gear during the New Deal era, when President Roosevelt is making all kinds of new regulations, economic regulations, regulations of commerce, things that necessarily affect commercial activity. And a few of those get struck down until eventually the switch in time that saves nine. Remember, FDR wanted to pack the court. And eventually the Justice Roberts, not the current Roberts, but Justice Roberts, changes the way that he was ruling on these things, ends up ruling in favor of President Roosevelt, keeps 9 justices on the court. And the grounds on which the justices end up upholding President Roosevelt's economic policy is the Commerce Clause. So high water mark in all of this expansion of Commerce Clause is going to be a 1942 case, Wickard v. Filburn. Now let me just pause for a second while I tell you the facts of this case. All right, so in 1938, President Roosevelt had signed into law the Agricultural Adjustment Act. And part of what this act did was attempted to stabilize the market for wheat. I guess wheat had been fluctuating wildly. It's a Great Depression right now, and the supply of wheat was not consistent across the world. So what the Agricultural Adjustment Act does is it limits the amount of acres that farmers may use to produce wheat. And FDR does this on grounds of interstate commerce. So along comes Filburn. Filburn's a farmer. He grows wheat on his land, but he says, you know what? I'm not putting it in the stream of commerce. I'm not going to put that wheat in the stream of commerce. I don't need to sell wheat to people. But I have livestock that lives on my land, and I want to make sure that I can grow wheat for my own livestock. So what Filburn does is he grows wheat on his land, and this wheat is produced on his own land, which is solely located in one state, for his own livestock, also located on his own property, solely within one state. Does this have a substantial effect upon interstate commerce? Turns out, yeah, it does, according to the Supreme Court. And the Supreme Court says, yes, it's because Filburn would have been forced to buy wheat elsewhere if he hadn't grown wheat on his own land for his own consumption. Filburn's activities have a substantial effect upon interstate commerce, and therefore they may be regulated according to the terms of the Agricultural Adjustment Act. Filburn has acted illegally. Must stop growing wheat. I think that Supreme Court opinion is totally insane. I don't think the Commerce Clause, when you say regulate commerce between the states, I don't think that ever stood for the proposition that you could regulate someone's own activity on their own land for their own use. That's neither interstate nor commerce, but that's now what the Commerce Clause has been read to do. Obviously, it is very, very extensive at this point, and that's sort of the high watermark for the Commerce Clause. Pretty much everything is viewed to be interstate commerce from that point forward, at least until the Lopez decision. I think it's a 1995 case. The year might be 1 or 2 off there. I don't remember exactly. But what that case looks at is a law that said that basically a law regulating guns on schools, federal law regulating guns on schools. Well, Justice Scalia writes the opinion in that case, says, schools are not commercial activity. Children can't even buy guns. This is not interstate commerce. Congress can't regulate that. And since then, Commerce Clause has been walked back a little bit, but largely it's still viewed as fairly robust. Obviously not at all what Congress intended it to do when it was enacted, but that's sort of the direction that it's gone since its ratification way back in 1787. So something I alluded to earlier were what we call the negative implications of the Commerce Clause. So on the one hand, Commerce Clause says that Congress can pass laws that have a substantial effect upon interstate commerce. On the other hand, states may not pass laws that impose burdens on interstate commerce. And this is actually probably the livest area of litigation, at least as far as organizations like the Lex Rex Institute are concerned. What would this apply to? Well, this would be something like if a state tries to favor businesses within that state as opposed to those out of state in a way that unfairly burdens those out of state. We mentioned dormant commerce clause on our podcast last week when talking about the Texas and Florida social media laws. I talked about possible dormant commerce clause issues that could arise there. But all that to say, if there are any cases in which you see that somebody has been deprived of their ability to compete effectively in one state as opposed to other states, that is potentially a case that would have a burden upon interstate commerce, and one that we'd be interested in looking at. So please do send those cases our way. But that's all I've got to say about the Commerce Clause. Obviously, as I mentioned earlier, I think one of the most abused parts of our Constitution, and a really good example of what happens when courts don't stick to the original meaning of the text. So again, thanks for watching our video. See you again next week, and everyone have a great weekend. Night, everyone.